Good afternoon to all of you, and it is such a great moment today that I can imagine that the vibrations in the university have completely changed, and we are feeling so thrilled to welcome you, sir. And it's a rare privilege to welcome a mind that has not merely studied the law but has shaped the way we think about justice itself. And Professor Baxi's presence is always very, very inspiring, and his association with the National Law University Delhi is very special. With the fact that he has been a constant source of inspirations to the student, faculty, and everybody at this university right from the beginning. I've been seeing him for more than a decade, guiding to this university on multiple occasions. And his passion and his commitment and his contribution is simply unparalleled and probably very rare to see. And his dedication speaks itself for the fact that he has agreed to come to this place, whereas I don't think he is going very often to so many places now. And when I just cracked this conversation to explore if he is in a position to come, and he readily agreed. And a very nice thing he said, that it would be a great occasion to see my lost colleagues. So lost colleagues in the sense that he mentored faculty on so many occasions. We remember those book reading sessions in that meeting hall, and those memories are simply great. And I always remember, I have a photograph which I keep in a very cherished mode. In that frame, can you imagine, there are 4 people. I remember that day: Professor M.P. Singh, Professor B.V. Pandey, Professor Madhva Menon, Professor Upendra Baxi in one frame. So this is the advantage of NLU Delhi. And he has guided tremendously to this university. And I need not to say that his work is very well known to us, and he always guide us through his work that law is not just about rules, but about human dignity, power, and responsibility. His writings have challenged complacency, expanded constitutional imagination, and given voice to those often unheard. And an age where law risks becoming mechanical, Professor Baxi has insisted that it must remain deeply moral, critically engaged, and socially alive. His intellectual journey stands as a reminder that the true jurist is not only an interpreter of the law, but also a conscience keeper of the society. We gather today to reflect on a question that goes to the heart of constitutional governance, the idea of delegation of legislative power. There could be no better guide for us today to guide this very important, engaging conversation than Professor Baxi, and his ideas will continue to inspire generation of scholars and students. We look forward today just not only to listening him, but to learning, questioning, and thinking more deeply. I always remember, and we all admire that, I would say, a very extraordinary quality which very few people possess. He has a tremendous connect with not only the senior faculty and the young faculty, but the students also. I always feel very, very enthralled when I receive at times the readings from his side. Those are not general reading in the field of law. Those are the readings on which either I work, I take a special interest. So fact is that he understands that what interests me. So he will send a study on presence, wrongful prosecution, criminology, and some very rare material. I am always very thankful for his, and he's a very well-read person always, and his sense of connect with the contemporary world, emerging ideas, emerging technology. He has also suggested to speak on AI. Can you believe? And this is the the quality of evolving scholarship. That is the inspiration that we must draw from him. And I am very happy today, and sir, on behalf of the National Law University Delhi, on behalf of this faculty members and the students, we extend a very warm welcome to you. And the world is waiting to listen to you. And I am pouring in requests from all corners of the country to provide the YouTube link. And I'm sure hundreds, thousands of people are today joining him to listen. So this is a great occasion. Please join me to give a big round of applause to him. So, over to you, Jurist.
It is an extraordinary task actually to introduce Professor Baxi. The fact that it is very difficult to actually capture in a few words the word of a person like Professor Baxi. But for today, I will draw my inspiration from something which was said in the context of handling the day by people like Deepak Gupta and all this. When he was saying that he was a sociologist who brought people like Max Weber, Karl Marx, Derrida, even people like Lacan and all this to India, and actually understood it in Indian context and exported all those ideas. Same can be said about Professor Baxi. That he has brought all those scholars to Indian milieu, and also has, as the work of any scholar, has also tried to imbibe the values in a kind of a cross-cultural fertilization. And in a way, Professor Baxi has made Indian legal landscape truly global. And I will just say a few words, some of which has been suggested by Professor Baxi also. One, without any doubt, he has an elephantine memory. You talk to him on one subject, and one fine day or one fine night, you'll find that something comes from him saying, let's read this on that. Okay? And it happens that he never forgets. And this extraordinary not because of the fact that he sends it to me, he sends it to everyone, whosoever has come in contact with him. So that also is a kind of extraordinary cherished value of being an academic, that is sharing of knowledge. We nowadays treat everything as a private domain, everything to be protected with all kind of arcana and belly. Nobody should be allowed in access. We always thought that education is and scholarship is all about making it democratic. The other thing which is very extraordinary about him, that is, I will not use the term activist because activist has its own connotations. He actually brought the working of law to the doorsteps of the people who may not be having a kind of a classroom interface with law or interface as we understand in courts. So I always urge, and I always tell some of my students must be aware of all this, that what is about Indian legal system and how there are non-state legal systems which are equally functional. Like I always recommend his work, across and all those kind of words, where he tries to understand how it is not only about dominant hegemonic idea of state legal system, but so many other things. So, but I can just go on and on. But and again, I really feel like a fanboy when I'm trying to do something. This is one of those rare occasions because we have seen him and we have been fortunate enough to talk to him for a fairly long period of time, and then we get to know the person, what the person is. So, without saying much more, I invite Professor Baxi to take over this slide.
Thank you, Professor Baxi, Vice Chancellor of the University.
Speaker on करता
Distinguished
yes volume बढ़ा
colleagues.
yes
The I'm a jurist, and I don't speak too much, but thank you for inviting me on this occasion of jurist speech. I remember on this occasion, Beloved Krishna Iyer, who wrote to me a letter when I became the Vice Chancellor. I've beheaded two universities. One is South Gujarat University, I became Vice Chancellor of South Gujarat University, and then of Delhi. And it's a good distinction to have. And he wrote to me that now he will become an educationist from being merely law teacher. Krishna never said anything that didn't have a sting in his tail. And he said also, and I never forget that saying of his, remember Oscar Wilde. Oscar was a great Irish wit, and he used to say, the more a person, more eminent a person is, the more things he or she has done to be ashamed of. So in a sense, I come to you before you all as that kind of eminent person. I'm very glad to be here, Mr. Vice Chancellor. It's very nice to be big friends, distinguished faculty and colleagues on this occasion. And for me, it's a kind of return of the native. As it were, it is my the NLU dialogues that I had with my colleagues have shaped much of my later juristic writing. So I'm very glad to be here. What I've done, NLU has contributed to my personal growth in many different and distinct ways, which I will not elaborate this time. First time we have witness to the kinds of influence that NLU community has exerted on me from time to time. I'm delighted to be back here. I'm delighted that Anuj thought about me, idea of jurist speech. NLUD was my favorite haunt. I speak in past tense, but it is still my favorite haunt. And I frequently visited his library and stayed in the guest house. It goes without saying that Dr. Baxi's sterling leadership and his colleagues' efforts have very greatly enhanced international and national esteem of the school. And I am sure it will continue to be at the masthead of legal education, news, views, and research. May I extend all my good wishes for the future. The future is a bit globally turbulent, as you know. But as Friedrich Nietzsche, the great German philosopher, once said, that you must have chaos in you to give birth to a dancing star. So the chaos is a lot of useful work for the society and its generation. And I wish you a very beautiful chaos in that sense. And my presentation will also be quite chaotic in a sense. I'm not a very systematic thinker. I wish I were. But it's too late to remedy that deficiency. Or probably too early, whichever way. And talking about being too early and too late, I do thank you very much. I believe that human rights of the living are best respected by respecting the human rights of those about to be dead. So I approve the obituaries that were sung by Dr. Baxi and by our friend here. which I'm a human rights person, so I believe in right of everyone to have his obituaries, his or her obituary read during his or her lifetime. And I fully approve of those which were now just said about me. I fully approve of this obituary. So coming to the, I think we live under Dr. Bhatta, who has said very well in Warwick, as their colleagues, that we live in very difficult, if not impossible, global times. And we cannot take anything in the world for granted anymore. If there was ever such a good time, probably there was a Satyug when we could take things for granted. But a long time ago, years ago. And what happened with the concept of time, which is quite baffling. But yoga is the most baffling of all the time concepts that I've seen. I will go to that, but I would say that we think therefore very carefully in the present times of the great little book by Ginny Servant McAuley called The Pedagogies of Collapse. Pedagogies of Collapse. A hopeful education for the end of the world as we know it. This was written in 2024. And collapse is now even more visible in 1926. And she wrote about the end of the world as we know it. So we are talking about everything in times of collapse. And recently I wrote an article on this Varsha Bhagat Ganguly and from Ahmedabad, Megan Finn, and Megan Finn from Africa, and Madhuri Paik from Ahmedabad, on social legal challenges for legal education and social justice. And when I named this education as LTTW formation, I often ask the question, why are teachers paid so much compared to the daily wage earner in India? And I never found a satisfactory answer. Our daughter Upendra Baxi, who is now a professor in JNU,
Yes.
is earning more than I ever thought I would earn ever in my life as a professor. So academics are very well paid. And I often ask myself, why in a poor country like India, academics are so well paid and continue to be well paid? After long thought, I came up with the idea of LTTW social formation. Now, what is LTTE? LTTW, sorry. L is learning, T is thinking, another T is for teaching. Learning, thinking, teaching. Or talking. And writing, whatever. LTTW. This is what we are paid for, an obscene sums of money every month, not to speak about pensions, which are theoretically due only for services rendered. And put your hands in your heart, everyone here, and everyone listening to me, how many of us can say that we have rendered those services? So it's a very serious question. In a poor country, why should teachers be paid so well? compared to the primary and elementary school teachers, more paid compared to infinitesimal or something like infinitesimal, small amount. And we call ourselves in higher education. Why we pay so much? Why should we pay for so much? My answer is LTTW. Learning, talking, thinking, writing. And let us put our hand on our hearts and find out whether we do it. I won't go into the question. This is not my main subject. But I have given up asking this question, I've given enough thought to the question as we move towards a new and post-liberal world, this order. It used to be order a while ago, but it's literally disordered world that we live in. There are two paradigms or models of LTTW. Which one is the model which is called BAU, that is business as usual. Let anything happen to the outside world, let the business of law teaching go on as usual. That's one way of responding to learning group or teaching group. Another, which I favor and which I call CCP paradigm. CCP is crisis and contingency paradigm. So law teachers or more teachers in universities, I firmly believe, should move away from BAU model of teaching to crisis and contingency model of teaching. And then perhaps you can make a case, some case, for earning so high in a poor country. But this is not the thematic of my discussion today. My thematic is what I call hyper-delegation, or what is called, I don't know. He invited me to select a subject. And very kind of people invited me again. And this is a very familiar phenomenon. And we may well talk about this separation of powers and doctrine and all that. But it's really the case that we are ruled by, we are governed by delegated legislation, executive government. If you think carefully, and we'll try to do that in the course of this discussion, we are actually ruled and misruled, governed and misgoverned by executive legislation. There is very little that we can call parliamentary legislation. Look at the author, once he wrote a very nice German author, I remember his name, Eminent. Just the computer now. But he wrote he used a very striking phrase. And the phrase was, I quote, ratification robot. The legislature is only progressively becoming a ratification robot of the executive government. So when we might talk about separation of powers, it's not the real thing. The real thing is lawmaking by the executive. And my friend and colleague Amita Danda and Nalsa has worked very heavily on what is called subordinate legislation, rules made by the executive. I stumbled into this phenomenon when I was teaching administrative law in Delhi University. I don't know what system you follow, but we Delhi University the dean had introduced the idea that one could give 3 choices of subjects for teaching, and out of 3, any one might be allocated to you. And the senior most person will take all teaching of unallocated subjects, unpreferred subjects. I did realize that by virtue of my designation, I was senior most. Because I've taught all subjects in law, including estate duty, taxation, you name it, labor law, I knew evidence, and things about which I knew nothing, but I learned. When estate duty, I taught so well that in a year's time it was abolished. It's my real contribution to legal education. I'm not very often noted. So I've been responsible, the way I taught estate duty, for the abolition of the act. So small contributions we teachers can make. But this contribution is notable because the whole law was repealed because of badly taught. And I have evidence for that, but I won't go into that. So I think essentially we are governed not by a law made by Parliament, or law made by judges, or law made by responsible politicians, that's governments, but law made by administrative regulator, administrative personnel, who are not supposedly accountable to people. General idea was that law must be made by politically responsive executive. But law was made, the very nice book in the 60s, in 1960s, that date, carbon dates me of course. The book is still worth reading. It's authored by a man called Arthur Kessler, Kosler. Arthur Kessler wrote a book called The Lotus and the Robo on Japan. But in the last chapter, when he said India is not a democracy, but a bapocracy, which it was so. It is not a bapocracy either. If you look at the impact of Bapuji on the Indian Constitution, please study just the bare text and find me instances. I found only 2 instances, Dr. Bajpai. From you, with the help of AI, I might find many. But I'm only saying lightly, but seriously also, I'm making a request. Because the only 2 I found that imprints of Bapuji on his constitution we adopted. One was the custom, another was prohibition of liquor. These are 2 very directive principles. He is only walking through these two influences. So, I think what we live under is not law made by Bapuji, not law made by elected legislators, but law made by faceless, unaccountable administrators by bureaucracy. Now I have a whole range of words for bureaucracy because bureaucracy is not a simple phenomenon. It is aristocracy. It is epistocracy. Bank prescribed knowledge is it is anything but regulatory, anything but democratic legislation. And it is this that I want to speak about. We must speak about. Oh, nothing moving. I'm already outmoved. We must talk about delegated legislation. Now, Constitution is relatively silent on delegation. It's my number one that I wish to make. And a practical emergency happened when we became independent. So the first major solution is through an advisory opinion of the Supreme Court. Because we had Part A, Part B, and Part C state. And what laws to apply to which state. Before the Constitution was amended and reorganization of states, report was submitted by Gadar and so on. That's a long history. The question was, you had to delegate, for example, the Bombay Prevention of Begging Act for the Plateau Delhi. You had to make laws for a partition-ridden India. India was a very vast legal landscape, and is in vaster legal landscape. So delegation became useful arm in the time, post-partition times, to extend law. For example, as I was saying, Bombay law on poverty was delegated prevalent in Delhi. So we legislators took law from one province, as they were called, British province, to another, and filled the lacuna in their own states, and then it grew. The practice of delegation has, in short, a linkage with history of partition India, which we don't study in the Constitution, we don't study partition. What kind of Constitution can we study, I wonder? Apart from Stirwat book on Constitution of India, which nobody now reads, there was a book on constitutional law which talks about partition of India. So what kind of teachers are we, or have been? To where does partition belong? To the history books, to the museums? What kind of law learners are we? What kind of law teachers are we? It's a question we have to ask. Which country are we living in? If partition is not relevant to us, in the violence, gruesome violence, partition is the position of women is not relevant to us. What is relevant to us? Anyway, I want to carry away subject. So let me simply say that the first problem was that legislations of the states were just being created, states were being integrated, and law had to be applied by imitation, by borrowing, by transplantation. Transplantation, according to comparative law, is only occurred in America or Canada or something. Transplantation also happened in India. Bombay Begging Act is still prevalent in Delhi. They simply were stuck down by Delhi High Court. Anti-begging Act. Apart from that part. Now let me get this done. So the matter was thought to be solved by advisory opinion in 1951 in the Delhi Law Amendment Act. Supreme Court gave the I think there's 5 judges or 7 judges. Each wrote an opinion. I won't take you through the whole judicial discourse of that. Better minds than me can do that. I have done it. But what the upshot of the Erosion Act was, ruling, was that legislature cannot delegate its essential functions. Now, what were essential functions? Then, quite 2 in 1950. First, laying down the policy of the law. And second, and I quote, enacting that policy into binding rules of conduct. That is, the policy, law must essentially, function of law is twofold: to make the policy and to annex it into sanctions. Annex it with sanctions. Now, please note that the idea of essential features of the Constitution originated in the Erosion Act case. That subsequently migrated into case of the birth. You study the history of Indian judicature. First time the word essential features was used, and I can help you again on this, was in the Erosion case. It didn't do through AI, I did it hard labor. But there's a point that you can do a lot more with that. In terms of textual contiguity or promiscuity, whichever. It depends. I don't think the dunder of its own.
It's genderless.
I don't know. I'm completely. What happens to dunder when it comes to it? I won't go there. It just occurred to me to create this question. And so the idea of original essential features comes from the Erosion Act case. And then migrate to Kishan. The idea is quite weird, basic structure and essential features. Just to be light, I often say to my students when I teach you, or my physicians nowadays, more so. So how are you, Dr. Baxi, how are you? Why you come to us? I said I was to use the language of the Supreme Court of India. My basic structure is all right. Essential features are upside down. Now the 2 words are used in case of the bar. One is basic structure and other essential features. What is the relation between structures and features? Why do you use 2 phrases? When one will do, I use basic structure or use the word essential features. But judges are impelled by verbosity. Our constitution is an object lesson of verbosity. It's very large. There's no business to it. American constitution is this much. That was 20 pages.
Yes. Verbose.
German constitution is small. Why do you say large constitution? Of course, NLU Delhi published a red book, so little red book of India. So that's the question. The 7 judges wrote 7 opinions at that time too. Incidentally, invite your attention, I can't go into it, in Article 145 of the Constitution of India. And while it allows for separate dissents, Article 145 of the Constitution does not allow for concurring opinion. It is there in the Constitution. Look it up. So most of the views of this court is unconstitutional. The Constitution says you can dispense with the separatism. But separate concurring opinion is not literary constitution, text of the Constitution. That is, give doesn't make it legal or not paralegal, I don't know. I don't want to go there. But I raise this question. Then if you take your Constitution seriously, and everything I do is taking it seriously. I take this thing very much. It's what you call my pesha. I don't go with structured mail or Tufan Mail Express or Vande Bharat train, speed, I don't know, bullet train or something. I go slowly and painstakingly and pause a number of times. In other words, I believe in reading. Galloping is not reading. You can't read as you run. So slow reading is the only way to read law. There's no way in which you can run your eyes through the left to right and left to right. I was at Berkeley as a student and my colleagues had done a course on speed reading. So this guy has read 50 pages while I was between first 5 pages. I got such inferiority in myself. Till I told myself, oh my goodness, ancient knowledge traditions. I said to myself, I come from a culture of 5,000 years. This fellow that was understood what I'm worried about. But again, I said, I don't want to speed it, I just want to read.
Yes.
I want to read slowly, not speed it. So, what did the 7 judges in their several opinions write? I can't go into the whole detail, but they said 2 things actually. One, the executive parliament is free to delegate its legislative powers to any extent. And remember the partition and the independence time, it's a context to it. Free to delegate its legislative power to any extent, subject to the limitation that it must not, and I quote, efface or abdicate itself. The correct expression is efface itself or abdicate its powers. That's the correct expression. But it said at the same time, it cannot delegate to another agency, and I quote, essential legislative function. And essential ELF for the side. Now, good, Supreme Court is just by way of arbiter dictum. Our Supreme Court is riddled with what I say, it says one thing, it says the other thing. It's overwritten at the same time. What's happening? It's overwritten by itself. So it says, what you can't delegate is essential legislative function. What is essential legislative function? The word essential comes essential religious practice, ERP, Article 25. The way you follow the word essential. Supreme Court, as per the Constitution is concerned, I'll double check, it never uses the word essential at all. Anywhere in the Constitution. But will you please have your colleague run a check for me?
Neeraj.
Will you run a check for me? Yeah,
Essential. We have to check,
Yes, I don't know. I know where the Supreme Court, it is essentially Article 25, essential public constitution, but essential. Anyway, so the essential legislative functions of delegation. And what does the legislature regard? Efface its powers or abdicate its powers. And it could not delegate, as I said, its essential legislative function, power to lay down the policy annexed by sanctions to any other body. Legislative function, in short, cannot be abdicated to Supreme Court. And some sort of policy guidance should be there. A delegation is valid when there is guidance, some sort of guidance to be had from the act itself. So the central legislative function can't really delegate. My very good friend Justice K.K. Matthew, on his book I edited some years ago on democracy, liberty, and equality, I say it does not behoove the Supreme Court judges to look into the nooks and crannies of a statute to find the guidance for delegation. And now the nooks and crannies have ceased to exist themselves. Earlier there were nooks and crannies. Now the appearance is dropped. Whatever the executive says is the law. Not what Parliament says. Let me explain how it happens. It has happened. And every student of administrative law in India knows this. First, you have to ask yourself the question, what you cannot delegate. What you cannot delegate. And it's circular to say you can't delegate your central function. Once, the only limitation that came was non-abdication. So long as you don't abdicate your legislative power, you can delegate. You can delegate and delegate. No question to be asked. So we in India, since the time of adoption of the Constitution, have lived under executive law making. Where do we talk about separation of powers? Case from the Bharti says in 1973 that our Constitution, and I quote, knows of no strict separation of powers. Strict separation. It does not know. So what is the strict separation of powers with the loose separation of powers? Now what now? When delegation. Who is playing, you may ask in a naive question, who is playing fast and loose with the word? I don't know. I leave it as a question. So you have some guidance from the provisions of the law. That means delegated legislation is not merely vague, but oceans of delegation. You are not talking of one single law to that. So all guidance is to be found from the legislation. Delegation is better. How first when I thought about it, I was teaching administrative law in Delhi University. Because I never said my specialty, I taught everything at the expense of my classes. There were two kinds of specialists. Specialists in Delhi University were either specialized constitutional law or international. Nobody opted for evidence, nobody opted for legal history, nobody opted for ordinary legal subjects. It's opted for everything. क्या हिंदी में सब बदल का व्यापार है Sambandha paper. At the cost of my class, I told him I can only study 9 or 10 hours a day, and I spend 9 hours of 10 multiplied by so many days a week, up to Section 15 of an act. I have not done any further reading before us. So I victimize you and you victimize me and we proceed. So teaching as a form of victimization is a very good idea. It says learning is a form of self-victimization and teaching is a form of victimization, but that's a different matter. What happened? Historic delegation. First of all, happened was what has been called skeletal legislation. Skeletal. As I was thinking, Delhi University, I taught something called administrative law. I taught also jurisprudence. I also taught statutory interpretation. I proposed to my colleagues and something called jurisprudence. Then we are deceiving ourselves. These four are so related that you can't teach one without the other. You must say jurisprudence 1 or 2 or 3, or administrative law 1, 2, 3, call it by their name, but of course although I was senior by virtue of being a professor, I was junior by virtue of having a number of years in the law school. So I yielded to the elders, whom presumably knew better than me. And I didn't press for it. But I think the first root shot was skeletal legislation. Skeletal legislation is, I taught administrative law, I taught two. I came across 2 acts. It's a perfect example of skeletal legislation. One was Import and Export Control Act. And second was Essential Commodities Act. I don't remember now, but kind of check out. One was 8 sections long. The other was 15 sections long. But in short, they were not long. Both short. And hundreds of notifications were issued. And notifications were the real law. In skeletal legislation, delegation is the rule. You cannot study, there's not a whole pretty word. I can study companies law today, or even the old acts like the Essential Commodities Act or Import and Export law. There is no hope in the world, to understanding that law without studying the rules made by the executive under the act. And many people don't study it. So if you don't study delegation legislation, rules made by the executive, and merely the rules made by parliament or legislature, you very often don't understand the law. You will go elsewhere. Go with the executive. It is a regardless, well, let's study better. I must say there's a House Committee on Subordinate Legislation. My friend Amit Adanda has worked very hard most of my life and compiled what subordinate legislation. A very important work. And what did the committee do? The impossible, in my opinion. What is impossible? The committee is saddled with the job of finding to make sure that the executive makes rules which are valid under the Constitution. If the Supreme Court does not know what is constitutional, how can a committee of parliament know? This is ordinary people elected. This is I'm summarizing it. But if you look at the report of it, I've looked at the reports of the Committee of Sovereign Research and produced studies on that. I will not go into that. Which seems to me that delegation is the rule and legislation is the exception. What you are supposed to, we all live under the executive rule-making powers. Executive dominance is a juridical reality, which is co-produced. Nowadays, it's very fashionable to say meanings are co-produced. Who produces what? It's a very big question in biology and other fields of knowledge. I won't go into that. But there is a lot of tacit thinking in that whole process. We should not go to patriarchy for the time being. But certainly, if you want to go into that, you can think of delegated legislation as patriarchy in a very big way. But that's the separate subject. Okay. So it is co-produced by two forces, by hegemonic executive and a deferential judicial approach, which validates the legislation. Delhi legislation is found in many ways. For example, some delegating legislation says you have to handle the eighth clause, handle the eighth clause. So every statute has something called. The difficulty is, if I may digress, we don't study jurisprudence. Jurisprudence is the wisdom of legislatures. Three theories: jurisprudence, three words. Jurisprudence, which we think we know the first principles of law, but we don't. That is jurisprudence. Who knows the first principles? I don't know. Do you? No. You don't have to say no. You can say yes. Okay, I can say yes. So, maybe, yes, it's based on the faith that the AI knows more than you do, more than we do. So maybe that's taking part for it. But that's a part. This is handling the eighth clause is a thing that appears in all statutes for the removal of doubts. It is hereby stated. What is the removal of doubt? Is the executive has the last word in interpreting the statute. And if you bear in mind the recent legislation like Data Protection Act and all that, the collect. So the provision Data Protection Act called it deemed consent. And who is the deemed? Who deemed the consent? But consent, deemed consent is consent which you are not given. Of your choice, it is deemed to have been given by somebody. When I was in Delhi University, I said there are two kinds of universities in India. That was before national law schools came into picture. But now I can say with greater power, those which are deemed and those which are doomed. I come to the latter class. But many fortunate people come from the other strata. So, in a sense, I'm deviating to the subject. But Henry VIII clause was named after English monarch. Henry VIII was known for his civic powers. And in one text, Henry VIII, so the remover of doubts. The executive can do virtually anything by making rules, and they will be well valid. The second is the test called not removed doubt, but abdication test. This was prepared by Justice K.K. Bedi in Warwick case, which made the power to repeal the act the touchstone of its validity. The legislative function was then not to be abdication, and delegation was then to be valid. No matter how broad or general it is. Supreme Court, not me. Parliamentary Justice Matthew. However, a majority led by Justice H.R. Khanna, the hallowed Khanna, did not agree with this abdication test and continued with the old test of policy and guidelines which we laid down. Almost was coming to an end. So although Justice Matthew in Papaya case found it very difficult, and he said, what way? It is very unedifying to look to the nooks and crannies of the statute to find guidance for delegation. This is what does it do? They scamper. They looked at the legislation of all forms of reason, somehow to find a guidance for delegation, and they found it. Isn't it the Supreme Court? Even the power to tax has been considered in the traditional Magna case. Tax and representation of people is deeply connected. If you remember the American Boston Tea Party and the Tea Party, and how American Constitution do, and the idea was no taxation without representation. That was the idea. Here the executive can rule us. Then I've gone on for too long. What do we lose when we lose, if we had to lose delegated legislation? And we said Parliament should make law, not the executive. Parliament is accountable. Why should the non-parliamentary epistocracy, knowledge bureaucracy, rule? The idea is that knowledge bureaucracy will rule because of domain knowledge. Well, why can't domain knowledge be acquired by parliamentary special committees? Who can call experts or suborn experts? The question has not been asked for. Practically not applied in India. How do we what do we do with this monster of delegated legislation? That's the question. How do we do it? And answer is there's a very nice song by Bob Dylan. The answer, my friends, is blowing in the wind. Have you heard that song? Have you heard Bob Dylan? Quite relevant to modern jurisprudence, particularly developed by Supreme Court of India. And Justice Felix Frankfurter in US, when he spoke about statutory interpretation, he wrote an essay called State with the Music. State with the song. So law and aesthetics are quite well connected, but that's not the point. The point here, I will conclude shortly, is we believe in Crustism. C-R-A-C-I. Crustism. What are the crustisms? One is econocracy. Econocracy. Nominally is
Economocracy.
economicracy. Yes.
Economocracy.
Cracy. Like democracy. Economicracy. Nominally. Second is regulatory cracy. Third is digitalocracy.
Please.
Fourth is epistocracy. That is domain again another kind of knowledge, but by domain experts. And these classes crush the ideas that legislation that governs ordinary citizens should be made by Parliament, not by delegated legislation. Nowhere does the Constitution provide for this. Constitution provides the six schedule. Central power, concurrent power, state power. Constitution does not provide for executive power. Or does it? I don't know. Maybe it does. Maybe my reading of Constitution is as thorough as that of a paid politician. Maybe. Yes. The Indian experience of rule-making by administration leaves much to be desired. Is it possible? I've asked Amita often, and she has answered, and she's written on that, Amita Chanda. But I ask the question still, whether are there any parliament and leading illustration that a parliamentary committee of subordinate legislation which have found that the exercise of delegation is outside the Constitution. That the function of a committee of parliament, a function where the Supreme Court justices cannot perform either. But let us grant autonomy to each institution. Can the legislature perform this committees perform this work? How often do they meet? And have they in fact performed this function? Have they held any legislature invalid? What parties, what the procedure by which this decision should take? How can, first of all, how can a non-judicial body decide that something is constitutional or not? It's for the court to decide. But if they can decide, what parties will be held by this committee to decide? And what grounds they will invoke to decide that? I end by saying, and then we can have a discussion. Two corporate lawyers, their names are Bharat Vasani and Varun Khanna, in a blog of Amberton Magadas on January 6, 2022. Said the following. I read them. What did they say? Quote, readers would be alarmed to note that since the enforcement of Companies Act 2013, the Ministry of Corporate Affairs, MCA, has notified 56 rules under the Act and issued 181 circulars. Further, around 225 amendments have been made to the rules framed by MCA. And 24 amendments were made in 2021 itself. Unquote. Then they further say, I'm giving something here, And I quote SEBI, Securities and Exchange Board of India. SEBI seems to be way ahead in the race of delegated legislation. Notifying nearly 80 amendments to its regulations, 80 in 2021. By what? By issuing 170 circulars, which indicate that the law is altered almost every alternate day. It's a law made by bureaucrats, altered by them every single day, alternate day. Far-reaching amendments could be made by simple gazette notification. This is leads to a situation where we, the citizens of India, may not even know what the law is at a given point of time. Well, you might conduct classes in legal literacy and seminars on legal literacy. You just can't go. The number of executive agencies, the number of executive agencies, the power of delegated legislation is so numerous and so vast. And they make so many legislations. So it has been described by these two corporate lawyers and described as what? Described as, quote, rise in delegated legislation. Can you look at that wrong? Rise in delegated legislation, don't rise and fall. Rise of delegated legislation. And therefore, how will the judiciary come into the act and look differently on delegated legislation? Not in my lifetime, at any rate. Which is already too long. But even by prolonging it by 2 years. In your lifetime, maybe if you're interested and you make a social movement out of it. But you have many other noble things to do, I'm sure. The Generation X, Generation Z, maybe AI can do something. I don't know. So, the point is not about safeguard. Believe me, safeguard is just a word play. What safeguard are you talking about? How can you arrest this chain of delegated legislation? You cannot. And you grow and grow. You know we are go back to ancient knowledge system, no?
IKS.
Indian knowledge system. There's plenty of figure I've told you about Brocozer. Brocozer is demons whose appetite is unsatiable, insatiable. And he goes on eating everything that comes, eating the whole world ultimately, and still his appetite is higher. So, this idea of delegation of legislation leads to two very antidemocratic tendencies. One, we conduct our lives as citizens more under the shadow of parliamentary legislation, which can also be short, passed, 5 bills passed in a day or 2 bills passed in 2 minutes. But let us not downgrade the parliament so much. Parliament is a deliberative body. And there's a good days and there's bad days. And opinions are vary, but the bad days are more than good days. That's a matter of opinion and study. I won't go there. But it is a fact that we live under an unquestioned and dominating era of delegated legislation. Rules made by bodies other than parliamentary legislature. Second, we produce ever-increasing legal literacy. Because nobody knows enough about the relevant laws that rule us. It requires a lot of hard work. So, in fact, we are led to an anti-democratic consequence of not being able to know what law rules and where is it to be found. Anilita Mukherjee of NASA had written 2 or 3 very good articles on the subject, in which she is a student of Metadata, in which she has written and showed, can you do have access to it? Anilita Mukherjee, she said, the Indian law not really fosters legal constitutional illness, but is unknowable. It's not a question of legal literacy merely, it's a question of unknowability. So I gave you this. Something funny about this. You might be teaching delegated legislation. I didn't mean to disturb the rose garden. But it occasionally happens when they invite bullies to a China shop. So there's no time. Jurist, both the China shop speaks properly. So I end here. And if you have any questions or comments, criticism, you're welcome. And we'll all answer.
So, floor is open for questioning. We present and asking questions and be clear. Yeah. So, my question. You take one by one or complete?
As you like.
Please.
Anybody is willing to ask or comment or say something?
Yeah, most welcome.
Yeah.
Okay, we have Dr. Sophie here. Is a faculty member here.
Oh, yeah.
Sophie.
Deciding officers. So they are deciding the matters. So the executive is penetrating into the judiciary now. So when we look at this legislative default, if we may call it, how do you look at under theorization of this legislative default? Because legislature did not act, or legislature facilitated this penetration of executive into judiciaries. How do you look at this entire instance?
Labor law is, I'm talking of mediation, or I'm talking about litigation. Because it's a function of different agencies, and labor officer will decide this, whether the industry dispute or not. And secondly, that the judiciary will decide whether it's one idea. So I was not attending to the burdens that judiciary is given, and judiciary imposes and distributes of facilities to India. I'm not talking about today. I didn't get your question. Say it again.
Yeah.
Is it? Yeah.
So under the industrial relations law now,
Just wait.
Yeah.
we have two adjudicatory institutions. One is Labour Code and the Industrial Tribunal.
Yeah.
And under the Industrial Relations Code, 2025, which was notified in 2025. The deciding officers in the industrial tribunal is Labour Commissioner or Executive Deputy Labour Commissioner, who has 5 years experience in conciliation or in the Labour Justice Administration. It's not necessary that the Deputy Labour Commissioner should be learned in law. So they are going to be the deciding officers of the tribunal. And Labour courts now, it is abolished. Earlier as well, by 2010 amendment under the Industrial Dispute Act, even within Labour courts, there was this administrative officer who became presiding officer. So this may result in the industrial tribunal currently, there can be one presiding officer, which is an administrative officer. The other presiding officer is a judge. And the matters can be decided singly. Or certain matters would be decided jointly. So we see that this would result in certain matters or probably a foreign shopping that can happen with the administrative officer who has become the presiding officer now in the industrial tribunal. Slowly, this executive is even becoming the judges in the labor adjudication machinery. So it's also executive getting into the adjudication machinery. So in the context of this discussion, I was looking at how, just reflecting on how the executive becoming a decision maker even in the adjudication. So these instances post 2010, especially in labor law, the executive is becoming a decision maker in the entire adjudication system. It's true that in German law or in UK law, we have this system of labor becoming part of advisory board of labor adjudication system, but it's not of this gravity.
Yeah. But the question of delegation arises in the terms of what? In terms of labor law bureaucracy, as it were, issuing circulars, issuing rules, and therefore being unaccountable at certain point of time. That may be the case. I don't think there is any area of law that is untouched by delegation. It is labor law, it is business law, whether it is this law or that law. Delegation occurs everywhere. In theory, one can maintain that delegation is a necessary evil, that you cannot do without delegation. In theory, one can also maintain that delegation is both impermissible and evil, because it is undemocratic. It is transfer the power of making mining legal obligation and citizen to some other body than Parliament, responsive body, or legislative. Now going back to here, take a view on whether all delegation is all illegal, or some delegation is necessary evil. All delegation is not evil at all. But it is how you conduct your business, how you conduct your business of government. So one can take any of these three views on the subject. And clearly, the third view is taken by the executives. You ask any IAS officer or any officer of its field, it's a delegation, that good thing. That's what makes governance possible. Then others have to it. that it is more efficient to delegate. And therefore, some bureaucrats would support the idea of justice matching. That shows had the legislature vacated the field, abdicated the field, then it is excessive delegation. But if there is a laid down some dullness which you can hold on to, within which delegation may occur, then delegation is valid. So, the views are very sharply divided on the issue whether you can have good governance with delegations. Or good governance is negation of delegation. That's the question. So and that's why the whole idea of excessive delegation. But the power to tax is considered invariably legislative power. Now, it's not my life the case, but your power to tax has been delegated in a number of situations. By no taxation without representation is a phenomenal rule. We tell us that in other cases, you find that executive can impose fines. If you executive can impose some penalties, executive can do. It's a parallel legislature. If you want to tax, you must give that expression. It's not a delegate, it's a parallel legislature. It can do anything that legislature does. So now these are typically Baxian outpourings. They are not to be found in literature. I used to call them.
Yes.
I have a, oxymoron. I'm a Baxian. It's a Baxian. Second, it's not to be found in literature. But Baxian are very natural Baxis. And I often found it useful to be Baxian. Some people find it useful to be oxymoronic. But that a very system will discuss.
Yes.
I see.
So, I suppose all good things must come to an end. And anybody else, if you have any pressing, okay, there are two. So, both of you can first say, then he'll probably jointly answer.
Good afternoon, sir. This was really enlightening for me, sir. I'm a practitioner. I work in a public sector undertaking in electricity laws.
Oh, I think.
Sir, I'll just give the context and then ask my question. So, what has happened in the electricity industry in India is that in 1996, post-liberalization, when India wanted to heavily invest in its development story, it sought loans from World Bank, International Monetary Fund, and ADB and all such agencies. They insisted that we would want independent regulators in India before we can agree to provide such loans.
Right.
And on their insistence, certain acts came into picture. The relevant one for me is the Central Electricity Regulatory Commission Act of 1998. And thereafter, federally, there are similar regulatory commissions in the states also. Now, the idea that was promoted by the World Monetary or Financial Institutions was to basically disassociate something which is essentially capital intensive from political interests, political motivations, and all that. And what has transpired is definitely anything but that independent kind of regulation. today CRC has more than, the Central Electricity Commission has more than 30 odd regulations. Whereas the Electricity Act, which was amended and notified in 2003 after the commissions came into place, has only seen a couple of amendments, but there are umpteen number of regulations all across India, and the commissions also exercise adjudicating powers, and there is a mix of technical, financial, and judicial members on the bench. Now, in this context, what I want to ask is, sir, that anywhere in this jurisprudence of delegated legislation was originally there any concept of that of being a dichotomy of how delegation would actually come out in public laws vis-a-vis how it will act out in commercial or private or financial kind of laws. Because where we are seeing the maximum amount of regulation and regulations which nobody understands are in these sectors, be it SEBI, Competition Commission, or the Central Electricity Regulatory Commission. And they are everyday decisions, and I'm actually literal when I say that. Their everyday decisions are impacting our pockets. So, can it be located? Any distinction? Because we are essentially borrowing from foreign institutions, we are transplanting what they have already worked with in the past. And what can we do forward if there is no such distinction to kind of rein in or just separate out such bodies based on law, policy rather than in law?
Okay, long question.
I'm sorry.
Thank you.
Parallel lecture. It's okay. Sir.
Simply put, if I may,
Yes.
Jayadubas, my friend, had written extensively on this very subject of electricity regulatory commission. Now, the question arises whether regulation is, although delegated, is a distinct field than delegated legislation. There's a difference. Regulatory agencies are peculiar to a particular state of business. And regulation is aimed at making that particular field more efficient and more productive. So there's a whole design of regulation which, for the lack of better word, I would say, bypasses the issue of delegation. It's a very important point you raised, if I may say so. Because today the common word used, you don't hear so much, apart from ex-administrative law teachers, of this word delegation. You don't worry too much about it. I know my selected the subject in the first place. I'm comfortable. But because I know a number of other subjects, it is very interesting that regulation is not considered delegation. It's considered a separate field. There is Competition Commission, Electricity Commission, which Jayadubas worked on this, and there are many other regulatory commissions. The idea is to improve the productivity and efficiency and pricing and output of a particular area. Conceptually, the question is whether there's something that we call regulatory institutions are a form of delegation or are separate entities, and conceptual entities. The most favored answer of the World Bank and IMF is that regulatory agencies are a new breed, new type of agencies, which are domain-specific, which have nothing to do with the issue of delegation. And maybe they will be right. Because India has seen several regulatory commissions. And this is in India many years ago. There was a Manmohan style, Manmohan Singh style. So, I'm saying to you, I don't know the answer. I can make out the answer. It is difference between delegation and regulation. If there is one such distinction to be made.
Yes.
And I think you can reasonably make a case for saying they are distinct. They are related, but distinct. They look like have something delegation. But I had actually a student who worked on this in Warwick University. On this very issue of regulatory institutions. I think he published a book, I remember the name, I give it to
Sure.
NLU Delhi, and they passed on.
Yeah.
Now,
There are actually many questions, I guess.
Aditya was there. First name was Aditya.
So we can now request our registrar to offer the vote of thanks for closing. I know it's too tiring for him. It's a long session. So we can talk outside also. Please come.
Respected Professor Upendra Baxi, our Chancellor Professor Bajpayee, dear members of the faculty, distinguished guests, dear students and friends. As we bring this enriching session to a close, it is both my privilege and my pleasure to offer a few words of thanks on behalf of the National Law University Delhi. At the outset, we extend our deep gratitude to Professor Baxi for a truly illuminating and intellectually stirring address on the theme Hyper-Delegation of Legislative Powers, a constitutional necessity or erosion. This was not merely a lecture, it was an invitation to question, to reflect, and to re-examine some of the most fundamental assumptions about constitutional governance in our time. Dr. Bakshi's reflections reminded us that constitutional debates are never merely technical exercises. They are at their core conversations about power, responsibility, and the lived experience of democracy. This characteristic clarity, moral depth, and general provocation compels us to think beyond the settled categories and to engage with the deeper implications of delegated legislation for democratic accountability and constitutional legitimacy. For all of us present today, this has been an experience both humbling and inspiring. We are especially honored by Professor Bakshi's continued engagement with academic institutions and scholars. His willingness to share records of wisdom with such openness and generosity is something we cherish deeply at NLU Delhi. Sir, we thank you for not only for today's session, but for the intellectual legacy that continues to guide constitutional thought in this country and beyond. I would also like to acknowledge the efforts of Vice Chancellor Professor Bajpayee, the coordinator, Professor Neeraj Kumar, who all conceived this and organized this session with such care and foresight. By bringing conversations like these to the forefront, they reaffirm our university's commitment to critical inquiry, constitutional values, and academic excellence. A special word of appreciation goes to our students, research scholars, and certainly my dear faculty colleagues. Your attentive presence, thoughtful engagement, and probing questions reflect the vibrant academic culture we strive to nurture at this university. It is forums like these that truly bring learning life. And I would also like again thank my colleagues, faculty colleagues, the administration, and all of those working behind the scenes, the technical staff. And we are live on online YouTube for ensuring the smooth conduct of today's program. In closing, Professor Baxi, we are sincerely grateful for your time, your insights, and your enduring association with the institutions of learning. We look forward to the opportunity of welcoming you back to NLU Delhi very soon. Thank you all for being part of this meaningful and memorable session.
Thank you.
Before we leave,
What's up?
I request Professor
Some-
Baxi, Vice Chancellor, to felicitate Professor Baxi.
Oh,
This we kept it, sir. This is there. Some
oh my goodness.
necessary formalities, sir. But those are very important, sir. I hope, sir, you will like it.
Again,
Try to learn, sir. This is, sir, simply a Madhubani painting for you.
oh,
So this will be very good. Kindly keep it in rest, you can keep it.
our
Let's do it like
good
this.
artist friend.
Yes,
Everyone.
yes. Yes.